All right, I'd like to welcome everybody back to another edition of Nassau COBA Monthly. I am Brian Sullivan, the president of the Nassau County Correctional Officers Benevolent Association. This is the August 2019 edition of Nassau COBA Monthly. Today, I am here with Sean Reardon, who is our workers' comp attorney. I'll have him introduce himself and the full name of his firm, and he's been affiliated with our union for quite some time. He does a lot of good work. A lot of our members have had work done with Sean, and we're very happy with the way things are done. He helps us out with legislation in New York State and locally in the county. And also this month, I'm here with Dennis Morris, the fourth vice president of Nassau COBA. Hello, Dennis.
Hello.
And Dennis handles all of our workers' comp and 207C stuff, along with a myriad of other issues. I'm going to kick it over to Sean Reardon right now, introduce himself, his firm, what he does, and we're just going to get into a conversation for a while here, maybe do two segments on workers' comp and 207C. So welcome, Sean. Thanks for coming down.
Thank you so much
Tell
for
us a little about yourself.
So I'm Sean Reardon. I am a senior partner over at McIntyre, Donahue, Accardi, Salmonson, and Reardon. We're doing workers' compensation. We do the three-quarters disability for you guys as well as Social Security disability and PSOB benefits. PSOB is a public safety officer benefit fund for the federal government as well. So workers' compensation, I mean, listen, the average guy understands what workers' compensation is, but he doesn't really understand, I think, the difference between workers' compensation and 207C. A little bit different. I handle the workers' compensation side. All the questions for 207C I leave to the illustrious Dennis Morris, who knows so much about the system. But workers' compensation, every time you get injured in the course of your duties, you have two simultaneous cases. You have the workers' compensation, which is run by the New York State Workers' Compensation Board, and you also have 207C. 207C is a different standard, which I'll let Dennis talk about. But workers' compensation simply means I was injured in the course of my duties. And really, what does in the course of my duties mean for us? Essentially, that you are providing some benefit to your employer. So from even arriving and parking in a designated parking lot to rolling around with an inmate is providing some benefit to your employer. So it's a wide spectrum of the type of injuries and the scenarios in which you can get workers' compensation benefits. So what do you do when you are injured? The first thing, and very important for all of the cases that we do, is make sure that you fill out and do it relatively quickly, the workers' compensation information, what you guys call your 85 I's. And what's the most important information that you put onto those forms is how you get injured, all right? 85I, your injured employee report, make sure you describe specifically how you were injured. That's going to be what we consider in the law contemporaneous documentation, so that later on, God forbid this does in fact turn into a three-quarters case, I can have some sort of information about how your injury actually transpired. Unlike workers' compensation forms, what we're going to probably do is just say, injured while restraining an inmate or assaulted by an inmate. Use your 85I form to really elaborate as to what transpired immediately before that took place.
And the more detailed, the better.
The more detailed, the better in that original injured employee report. The workers' compensation report will fill out for you. It's called a C3. We file it with the Workers' Compensation Board based on the information that you give us. But quite frankly, we generally try to keep those a little bit more vague and let you explain for the record later on what it all meant, okay? But when I get to a three-quarters case, the state does a little bit better job of evaluating the underlying evidence that you filled out for the employer, inclusive of that 85I. So make sure you put down the facts and circumstances that actually were involved in how you got injured. From there, listen, one of the biggest issues in workers' compensation right now, and probably one of the most frustrating parts of workers' compensation, is delays, all right? So once you file your workers' compensation, they can either accept the claim or deny it. Generally speaking, I would say the large majority of cases are going to be approved based on the facts and circumstances of how you guys get injured. They're not going to deny that the claim took place, right? Or the injury took place, I should say. Where are they going to actually spend their time? They're going to say, maybe you didn't injure this particular body part, or your doctor puts down that you need physical therapy or an MRI to that body part. And the conservative treatment is what the insurance companies prefer. So I get a lot of calls about, well, what are we going to do? My doctor's asking for an MRI. The county is actually denying it.
Because they don't want to pay for it.
They don't want to pay for it. Exactly right. So they think that they'll delay the treatment. You'll go away. You'll get back to work. But unfortunately, you actually have a legit injury that's getting worse because you're not addressing the actual root cause of it. Right. So ultimately, the insurance companies end up costing themselves more money on the end because you continue to use your arm in physical therapy or other activities, not knowing what's going on with it underlying. You could have addressed it with surgery immediately up front, but instead that surgery gets delayed. So unfortunately, work with your attorneys. We were always fighting on your behalf to actually get you the necessary treatment that your doctors are asking for. But that's one of the most frustrating parts of it is right up front. What are we doing? How do I get my MRI, right? How do I get the necessary treatment? So we'll always work with that. And quite frankly, for the county, Triad has been pretty good with getting us the necessary treatment and necessary treatment right up front. So what's the next phase of any case is getting you, once you're back to work, let's assume your injury is resolved after a surgery. Really, there's two types of cases, and this becomes important because one of the major issues that I'll discuss with workers' compensation right now. But there's two types of cases for those of you that don't know. You have a scheduled loss of use injury, which is essentially an extremity injury. You also have a permanent partial disability injury, a PPD as we call it, and most of your guys that have been through the system are familiar. So what's a scheduled loss of use? Essentially, the workers' compensation law itself sets forth what particular injuries are worth under the workers' compensation. So you injure your shoulder and you receive a 10% scheduled loss of use from your doctor. Usually the IME, the independent medical examiner on behalf of the county, will come up with a lower scheduled loss of use, and then we begin negotiations. Hopefully we'll either proceed to trial because we can't reach an agreement on something that is amenable to both sides in terms of the scheduled loss of use, or we reach an agreement as to maybe somewhere in between, usually on the higher side for us, on a scheduled loss of use that is acceptable to the county. We go to court, you sign off on that stipulation, and they send you a check. Now,
And acceptable to the member.
Oh, 100%. No, you have to sign off on it. If you're not happy with the settlement that you're getting, let's proceed to court. Right. And listen, one of the reasons why I think we represent a lot of unions in this state is, listen, we've put together a team of trial lawyers. All right. So we're ready, willing, and able to go to court on any particular case. If you're not happy, let's go to court and let's let the judge decide. And that's what can transpire.
Right.
The flip side of the scheduled loss of use is a permanent partial disability. Okay. So if you have a neck or back injury, that's what's known as classifiable type injuries under workers' compensation. Those types of injuries don't receive a scheduled loss of use. Instead, those injuries are payable only when you're out of work based on them, okay? Right. Because you have a loss of wage earning capacity while you're out of work based on those injuries.
Necks and backs are whole different birds.
It's a whole different bird, okay? Right. So only if you're out of work or do you receive any type of payment for a PPD. But how does that come into play with the major issue in workers' compensation right now? And in fact, it's affected your members specifically on a couple of relatively large scheduled losses of uses. So last year, as you all know, what's known as the medical treatment guidelines were created by the Workers' Compensation Board. And really what they did is just change how you evaluate different types of injuries, okay, including scheduled losses of uses and what are permanent partial disabilities, the PPDs. What ended up happening is they wrote one little line in there that said you cannot receive a scheduled loss of use if you have a residual impairment to the neck or the back, okay? So they independently wrote this into the permanency guidelines irrespective of the law. So what ended up happening, unlike the last, I think it's 90 years of workers' compensation, we've gone to court and an individual claimed a back or neck injury originally. They also claimed a hand and an arm injury. They were agreed with the county to a specific schedule loss of use. We put in the schedule loss of use. It gets agreed to. The board kicks it back and says, even though you've agreed to the stipulation, you are not getting your schedule loss of use because your doctor said you have an ongoing neck or back
injury. Right. Okay.
So the board has taken upon itself to actually disregard these schedule losses of uses that the parties are agreeing to,
right,
and kicking these things back. And that's costing members tens of thousands of dollars. Now, we don't think that they ultimately will have a legal leg to stand on. There's been numerous cases that have already transpired.
Mm-hmm.
The board's point is, well, those cases have not taken into account our permanency guidelines. I don't think that ultimately they'll be able to say their interpretation of the law is more important than the third department's interpretation of the law, since the third department, court of the appellate division, supersedes any administrative agency. But what does it mean ultimately right now is that I think we're going to have some problems pushing forward some of the schedule losses of uses for your members right now.
We seem to have a persistent recurrence of problems with the scheduled loss of use in New York State workers' compensation law, right? Every year, every couple of years, it comes up. We just had something, it was 2 or 3 years ago, where they were looking to do away with scheduled losses of use altogether, correct?
Yeah. Well, without doubt. I mean, 2017, there was a proposal for the law to basically eliminate all scheduled losses of uses. And quite frankly, Nassau COBA was one of the leaders that got that blocked.
Right.
So that happened. So what do? 1 year later, they changed these permanency guidelines.
Right.
And they could do that by
And they
themselves.
come at it from another angle and do it on themselves.
It's an administrative agency.
Mm-hmm.
They get to write the permanency guidelines, and they included this one line in there, which is, again, going to cost injured workers money. Okay?
Right.
But what are they doing right now? There was just a report for the first time in history. This is an independent report, and it was from the New School Center for City Affairs. So it was an independent white paper done, just a study on workers' compensation. For the first time in history, in 2017, insurance companies in this state made over $1 billion profit on workers' compensation insurance.
Incredible.
So while they're making the highest profit and 92% increase over a 4-year period, they're still trying to dig into your pockets and get your scheduled losses of uses and increase those profits even further.
Take it away, give them profits, and take them away from the injured workers.
100%. Right. So, there's a couple of pieces of legislation that I think, now that they're coming after the scheduled losses of use, I think we maybe have to reapproach the legislature,
right,
and say, hey, listen, we need to write this officially that you can receive a scheduled loss of use even if you've had a neck or a back injury in the past.
Right.
Number one. And number two, listen, much like that white paper called for from the center that did the independent study, is we need to increase benefits. We need to increase benefits. Right. We're the 28th highest state in the country in terms of workers' compensation benefits. Why is that? We were the first state to ever actually pass workers' compensation for the protection of injured workers, and we're starting to fall further and further behind in this state. We need to increase scheduled losses of uses. Right. We need to increase the rates that they get paid. And we need to increase, if the benefits, I think, on the PPD side, and consider that the injured workers should not be the ones that give in to insurance company demand for more money.
This reminds me a lot of what's gone on with the New York State Commission of Correction and legislation. They had the HALT. It's different from what you're talking about. We have the HALT legislation where they want to change the way we're handling disciplinary inmates in the state, and they didn't get the HALT legislation passed in the state. But Cuomo's appointees in the State Commission of Correction pretty much did everything that was in the HALT legislation, aside from having to provide money.
Just took a different route.
To the just take a different route. That's it. They do it through the back door instead of the front door. Instead of doing it through legislation, they do it through their appointees and That's whatever right. else in there. And they get everything in there. But the one thing that they cut out is any money that has to go to the municipalities or to the workers.
And the training.
Which is what it's all about. And the training. Right.
Yeah.
All right, we're gonna take a break here for a couple of seconds, and I appreciate everything that's gone on there. I know, Sean, we've had this conversation. You could talk for hours on end about what goes on with the workers' compensation system in 207C. But we're gonna take a quick break. We'll come back for our next segment. We'll get workers' comp in 207C. Excuse me. The next segment, we'll get into a little bit more 207C with Dennis and Sean, and we'll go from there. This is Nassau COBA Monthly, the August 2019 edition. Brian Sullivan will be back.
Stay up to date as to what the Nassau County Sheriff's Correction Officer Benevolent Association is up to. Visit NassauCOBA.com from your phone, tablet, or PC. There you can learn what issues Nassau's toughest law enforcement union is working on. Members can sign in on the private side of the website to get valuable benefit and services information, as well as meeting date details and charity event reminders. Members can also register to receive a private email called COBA Alert, news you can use to be informed members of Nassau COBA. NassauCOBA.com, the toughest job in law enforcement. NassauCOBA.com.
The Nassau County Sheriff's Correction Officer Benevolent Association cordially invites the public to visit NassauCOBA.com to sign up for the COBA report. This free email goes out periodically to keep our neighbors up to date on what's going on in the Nassau County Jail. The COBA report also reports on our charity events, community outreach, and issues we face working in Nassau's toughest job in law enforcement. Visit NassauCOBA.com today to sign up for the COBA report.
All right, welcome back to Nassau COBA Monthly. I am Brian Sullivan, president of the Nassau County Correction Officers Benevolent Association. I'm here again with Sean Reardon, our workers' comp attorney, Dennis Morris. And this next segment, we're going to talk, segue from workers' comp a little bit more into 207C and three-quarters, things like that. So I'm going to kick it over to Dennis, and we'll take it off from here. Go ahead, Den.
All right, thank you, Brian. All right, some of the things we're going to talk about, I know Sean touched on 207C and reporting it when you get hurt. Some of the misconceptions. First we'll start off with, what is 207C? It's a New York state law which gives you full wages and medical care for injuries incurred within the performance of your duties. So, some of the misconceptions, it has to be an inmate involved. No, it just has to be performance of your duties. I'll give the example. You're walking down the hallway on your meal period. While working, you slip and fall on a puddle of water. No inmate involvement? That's fine. That's workers' comp. You're on your meal period. Now, same puddle in the water. You're walking down and you're doing something, getting a disciplinary sign, you slip and fall in that same puddle of water, that's 207C because you showed that that incident or that accident incurred while in the performance of your duties. So when the inmate involvement comes is with 607C, retirement Social Security law, when it comes to three-quarter compensable injury, and that's like the ever-breathing document that changes what is an act of an inmate, right, Sean?
Sure, yeah, no, 607C is constantly changing. Not unlike 207C. 207C has lots of litigation regarding 207C. But the standards are basically the same for many, many years at this point. Whereas 607C, the standard keeps being attacked. And quite frankly, some cases that shouldn't be brought up to the highest courts in this state are being brought up and drastically affected.
And it's only strengthening their position on the act of an inmate, correct?
Well, it's given an opportunity to strengthen their position. You know, you want to bring the right fact pattern cases type up to the Court of Appeals, number one, or to the Appellate Division, number two, where we've been very successful, really, based on Nassau County Corrections. I mean, Nassau County Corrections, if you look at some of the number one cases that are cited in all of this state, they're Nassau County Correction Officer cases. So we've been successful in changing the law to our benefit. There's been some attacks recently on it. Yeah. You know, the 607C is a little bit different than 207C in terms of standards. So Dennis just said, you know, what are we looking at in terms of the standard? As long as you were performing your duties, you can get 207C benefits, and that's full pay. And you also said medical benefits. You have simultaneous medical benefits from workers' comp and through the 207C. So I just want to remind listeners and members that if you are denied benefits under 207C, you can still actually get approved for them under workers' compensation. Always something to keep in mind.
And I'm glad you brought that up because basically sometimes some of the things that happen, we can say, I guess, that workers' comp is a more lenient standard, could we say?
I'll say a better standard.
A better standard.
That we can certainly prove it a little bit more leniently.
Yeah, but okay.
More favorable standard, right.
Just because you're approved for workers' comp for that certain body part is not necessarily true that you get approved for 207C for that body part.
100%.
Can we say that?
Yep.
So if they say you have what's called a consequential injury, you got a back injury, now it turns into something with your hip, and now you're just out on your hip, it's not necessarily true that you're going to get 207C benefits for that. You're definitely going to get workers' comp benefits, but when it comes to the reimbursement of pay or full pay and medical coverage under 207C, that's something you have to actually put in for with the department and go from there.
I agree wholeheartedly.
Which could be a yes or no answer, the department has 30 days to say yes or no, and we'd have to go through our contractual process to get you 207C for that, possibly.
Absolutely.
Right.
Yeah.
And you actually had to have lost time to get 207C.
Well, right now we still have that arbitration open. We're going to see where
Right.
that goes right now. That's still coming up probably in September of this year.
Right.
There's a continuance to that arbitration.
Sure. Well,
Correct me if I'm wrong. I'm sorry. Was that a departmental determination, or does that have any legal basis?
That's a departmental determination.
That was only a departmental determination
Yes.
here, that you had to actually lose time before they would approve you for 207C.
Correct. So we still have that September, I believe, 16th of this year.
Right. Go ahead. I'm sorry.
so no, that's fine. Just talking about 607C. So 607C, different than 207C. You guys get that mixed up a lot, but 607C is your 3/4. It's known as your performance of duty disability under the law. Different standard than 207C. I have 3 elements that I have to prove legally. Number 1, that you're permanently incapacitated. Number 2, that your permanent incapacity is related to, and then element 3, the act of an inmate, right? So in my venue, unlike 207C, we do need the act of an inmate in order to get you that 3/4. Okay, right now, if you don't have the act of an inmate, but you are permanently incapacitated, the only other option for you is your 1/3 disability. Taxable. It's called the ordinary disability here in New York State. So right now, correction officers don't have that interim benefit like police officers. They have that interim benefit, kind of a 50% tax-free.
Accident incident, correct.
Yeah, and a lot of guys come in thinking that they also have that, but you don't, unfortunately. We were talking about legislation earlier. Maybe that's the next piece of legislation that we need to get up to Albany. But right now you have that 1/3. So I'm going to stay away from the 1/3. Talk to you about your permanent, your 607C permanently incapacitated because of the result of an inmate or the act of an inmate. So what is, the biggest issue with permanency, meaning that you are permanently incapacitated from your job as a correction officer. What has been the biggest issue that they deny people on permanency is really what's known as the reasonably safe and reasonably successful surgery denial. And that means that you could come to me and say, you know what, my back is killing me. My doctor wants me to do a fusion surgery, but I don't want to have that surgery. It's too invasive. I will tell you, then you're going back to work because there's no point in filing for your 3/4 benefit because the state has adopted the presumption that if you are going to claim permanent incapacity, you are responsible to have a reasonably safe and reasonably successful surgery. For people with neck or back injuries, that really means you have to have at least a single level fusion for them to consider you permanently incapacitated. That's the current standard. Some doctors may even push a double level fusion post-operatively. Some of these more, I'll just call them wacky doctors that work as independent medical examiners for the New York State retirement system will say even post-op double level fusion, you can go back to being a correction officer. Now, I don't even think that you can go back to being a correction officer with a single level fusion, but that's who cares what I think. All right, the retirement system will push that standard, and that's where we stand. So right now, if you have a neck or a back injury and your doctor is recommending surgery to that neck or a back, you should have it from a legal perspective. Okay, if he's not recommending that surgery, we got to have your doctor explain fully for the record why that surgery is not recommended for you in particular.
And sometimes people can't have things because they get blood clots and things like that.
Oh, 100%. Yeah, you could have
You
other
can't go under the
medical
knife.
reasons why
Right.
you cannot have that type of a surgery. No
Right.
doubt about it. So, but we have to have your doctor explain that so that that's taken into consideration.
Right.
Why it's not reasonably safe for you.
For you to
as
go
an
under
individual.
anesthesia. Right.
Correct. For extremity type injuries, my general rule of thumb is 2 and out. Okay, and guys always wonder what the hell does that mean? Excuse me. But 2 and out means 2 surgeries. If you have a shoulder injury and you've had 2 surgeries that are unsuccessful, we still have limited range of motion. You still have limited strength, maybe some atrophy of the arm because of you can't really use it all that much. Usually, we're going to get past that permanency standard. Okay, right. That doesn't mean if you've had 1 surgery and still some problems, we can't get you retired. But the general rule of thumb is 2 surgeries. And again, maybe an explanation why your doctor doesn't think a second surgery would make you any better. just kicking it forward to the second standard that I talked about. Remember, anything that we are trying to accomplish has to be related to your work and specifically the act of an inmate. So that permanent incapacity, that back injury that we were talking about earlier, has to be caused by the act of an inmate. So what does that mean? It has to flow naturally and proximately from that act. Meaning you could have degenerative conditions walking into jail, okay, on that particular day, but if that inmate did something that aggravated or exacerbated that underlying degenerative process in your back, well, now we have a case because it flowed naturally and proximately from that inmate act.
Right.
But let's say maybe the day before you were getting shots in your back, and for the last 2 years you've been on painkillers, and you went in and you also had that same act of an inmate. The retirement system may, in fact, come back and say, no, listen, the inmate didn't do anything to you. You already had this pre-existing condition that you were treating for with a doctor. Nothing really new happened. Therefore, it's not related. And we have seen some sort of denials, but we've been successful on appeal on those cases.
A lot of the things, Sean, people talk about just because the inmate was mopping the floor, let's say, and it caused you to fall. Let's talk about that act because that's a big thing that comes because people say an inmate's involved, it's 3/4 compensable, that's it. But that's not necessarily true, correct?
No. So the act of an inmate, that third element that I was talking about, really a line of cases, 3 different types of cases came out. The first one was called for what's known as direct inmate interaction, meaning the inmate had to have done something and you were interacting with that inmate at the time of the injury. Really, where did those cases emanate from? The first one was a case called Escalera. Doesn't really matter the name, but essentially a correction officer was accused of sexual harassment of the prisoners. He was fired, terminated. Then he filed for 3/4 and said, oh, I'm suffering from PTSD because of the actions taken by the department in firing me because of the act of an inmate. Court came back and said, no, that's not really related to the Inmates Act. It's related to the acts of your supervisors and the department. That has kind of carried forth, and people talk about response cases. A lot of questions from members about if I'm responding to the act of an inmate. The answer to that question is it can be and it cannot be. Okay, there's a few cases out there. A correction officer stands up to respond to an alarm and his knee gives out. Okay, well, the knee gave out because there was a process going on in your knee. That's not necessarily related to what the inmate was doing. That would have happened regardless. Okay, another response was guy runs in, and as he's running to the response, another correction officer hit him with the door, right? Is that the act of an inmate? The answer in that particular case was yes. Okay. And why? Because it flowed naturally and proximately from the Inmates Act. Those 2 correction officers would not have been in that spot if it weren't for the inmate. Okay. So that's a little bit different. Now, the second line of cases is what you mentioned. The benign chore case is what we call them. Okay. And the courts have consistently come back and said if an inmate is performing a benign chore, something like mopping, okay, or something where they put the correction officer, there's another case where they're picking up sticks. The inmate draws the correction officer close, and as the inmate the correction officer gets close to the inmate, he breaks the stick and it shoots into the guy's knee. Court came back and said, no, the inmate was performing a benign chore. The mopping cases, inmates mopping, maybe he does it on purpose, okay? That's the important part. And circling back to the comp paperwork in that 85I that you and I were talking about, if you think an inmate did something on purpose, okay, put it down. And we'll fight those types of benign chores. If you think that the inmate is using benign chores to get you hurt, let's fight those cases, okay? But include those details in your 85I reports so that we have some sort of ammunition.
And you have to be in the performance of your duties. You have to delineate in your reports that while in the performance of my duties, this act occurred.
But Brian, you can attest to this. Years ago, everything was short and sweet.
Right. Everything was short and sweet.
Short and sweet.
Right.
Now, you have to show.
Right.
Yeah.
That's all the litigation.
On
That's
that
all the
85I,
insurance
like Sean
companies.
said, on that injury sustained on duty.
That's the
medical
state not
documentation,
wanting to pay.
everything.
That's the insurance companies not wanting to pay. So the standards.
As I always say, listen, the bottom line is if there was an inmate involved, put it down in that initial paperwork and we'll work with it. Okay? So Last but not least, and this is the most important, probably the most important case that we have going on right now, is the affirmative act of an inmate, okay? And the affirmative act of an inmate means that the inmate has to do something that causes you an injury. So there's a couple of cases out there where inmates faint, correction officer catches. Is that an act of an inmate? And the courts, the third department has come back and said, no, that is not the act of an inmate. There was a case taken up, and it's called Walsh v. DiNapoli right now, to the Court of Appeals that says another type of similar case where somebody falls out the back of a van involuntarily because they're intoxicated. Is that the act of an inmate? The third department said no. The case was taken up, and we're going to see. The Court of Appeals can come back with, a real decision that's going to affect the entire state and what does and does not constitute the act of an inmate. And we're going to see. I mean, it's a very important case.
Here we go again.
And probably coming out later on the next year.
Probably a couple months back, you put an article out, Sean, on a light duty standard.
Sure.
With New York State. The New York State Code, I believe, was 364.3.
Yep.
Back when. I think when you get 207C, there is a good chance sooner or later, if you are out, that you will be back restricted duty at some time. Right. Now, coming back, I know the standard to go out to retire 3/4 is that you cannot do the full-time, full-duty job as a correction officer. So light duty has no play in it, but light duty does have a play in certain areas. So if you want to get into your article a little bit and just let us know.
Yeah, it's not written in the law. So the codes, rules, and regulations for the New York State retirement system say if you work 100 hours of overtime in a light duty spot, or you work in a light duty spot for 2 years or more, that light duty job becomes your job for the retirement system's analysis of whether or not you're permanently incapacitated from your full duty job, okay, or from your full your job description, I should say. So I'm a correction officer that works 100 hours of overtime in my light duty job. It is that light duty job that the retirement system will take into consideration. Okay.
As now the standard that you can't do clerical work now.
That's right. Yes. And almost never am I going to be able to retire you. So always keep track of your time in a light duty position.
That's not necessarily January to January. That could be.
No, so that's the 100 hours. I'm talking specifically about the 100 hours. But you're 100% right in terms of the 2 years. Okay. So just assume, again, quick hypothetical. I'm a correction officer. I get hurt on January 1st. On January 3rd, I come back on a light duty position. I work that job 1 day on January 3rd, and I say I can't do it anymore. That 2 years begins running that 1 day, regardless of how much time you spend in that position. January 3rd, 2 years later, that job becomes your light duty job. Okay? So you have to make sure the code calls for your 3/4 application to be filed before that 2 year marker. Okay? So if you're not back to work and you've worked in a light duty spot, make sure you file your disability pension application before 2 years of that date that you returned in a light duty spot.
Even if there's a chance you might come back just to cover the benefit, you might want to file anyway and retract if you had to, correct?
100%. We can always withdraw an application if you subsequently get better and return to work. We can't subsequently try to get your full duty spot to be considered by the retirement system if you pass that 2 year.
Like everything else, keep track of your dates.
Some of the issues that we've been dealing with is with the staffing in the jail, as Brian's been talking forever, is ordered overtime. And how does that affect that standard?
Ordered overtime is still considered, okay? Under current New York State law, mandatory overtime is still overtime. The court came back and said mandatory overtime was contemplated by the legislature, so it still counts.
They don't look at it as two separate.
And also, as we see, the department contractually says you could work on light duty without being ordered by a supervisor in an emergency up to 16 hours.
16 hours a month.
Far exceeds that standard anyway.
100%.
The New York State Code.
Keep track of your light duty. That's the lesson.
Fellas, I'm going to have to cut this section there. There's obviously a lot we could talk about here. We're trying to get it into a little bit of a condensed form here. We can certainly bring Sean back and talk about different issues with this stuff, but we try to keep things as concise to keep everybody's attention as possible, because we could go on here forever about a lot of these issues. We're going to take another break right here. This is Nassau COBA Monthly. I'm Brian Sullivan. We'll be back.
The Nassau COBA Widows and Children's Fund was established in 2006 to benefit the families of deceased Nassau County Corrections officers who died while in active service in the department. Since its inception, this fund has distributed over $59,000 to the widows and/or spouses of our brother and sister correction officers who have unexpectedly left us too soon. These payments are made at the time of their death to help defray some of the funeral-related costs. The fund has also helped defray some of the costs of medical hardships that our active members are experiencing. Since 2006, over $22,000 has been distributed to our active members facing need due to medical emergencies or undue hardships. You can help today by visiting NassauCOBA.com and find the donate button on the Widows and Children's Fund page.
All right, everyone, we're back. Brian Sullivan with Nassau COBA Monthly, the August 2019 edition. And we're going to do one more short section here with Sean Reardon, our attorney, who just wanted to explain a little something about Social Security for our members.
Yeah, the complete disability system, we talk about it in the firm when you come see me, is in addition to workers' compensation and the pensions, we talk about Social Security disability with the members. And Social Security disability, I think, is the best system that exists in terms of a disability system. It's the fairest system, and it is certainly, I think, the most understanding system for anybody that's going through a disability. Good thing came out this past April, as a matter of fact. Social Security disability. I know a lot of guys. I get a lot of inquiries about funding for Social Security disability. Will it be there when we get older? Short answer is, in 2015, they reallocated some of the FICA tax, put it into the Social Security Disability Fund. So the Social Security Administration announced just this past April that it is funded, 100% funded until 2052, which is 20 years further than we were even last year. So that's a big thing. We're funded. They're 91% funded thereafter for the rest of the century. So it's going to be there for us if we need it. That's different than the old age fund, the normal Social Security fund. Where that is certainly under a little bit more economic stress, but that's still fully funded till 2035, and then 80% funded until the rest of the year. So Congress is going to have to address some issues with the funding of the old age fund. But going back to the Social Security disability, that's the best system, but it's also the highest standard, right? So you have to be permanently incapacitated from all jobs existing in the national economy because of your disabilities, okay? So that is much different than the 3/4 that we were talking about, right? So I have to prove there that you're permanently incapacitated from being a correction officer. And workers' comp, I just have to prove that you're injured in the course of your duties. Social Security is a much higher standard. So I want
you can't work anywhere.
You can't work anywhere. So if you're under age 50, that means, not to downgrade people who work at McDonald's, but working at McDonald's making the fries to being a brain surgeon.
Right.
That's the full spectrum of things that I have to prove that you can no longer do. So that is not a system for everybody, right? So if I retire you on a shoulder injury from New York State on your pension, or your knee injury, or your foot injury, or a finger injury, that doesn't mean that you're going to roll into a Social Security disability application or that it's right for you and your family. Right. So make sure that you have that conversation with me. And I'm going to be honest with your members and all applicants. This is a good idea for you and your family. This is more likely than not something I can get through, but it's not necessarily, especially if you're under than 50. Social Security disability is running a much more stringent program than they did even maybe 10, 15 years ago, where if you're under age 50 and you have limited disabilities, you might not be able to be a correction officer anymore, but you certainly can be something else,
a productive member of society.
And let's get you back into another position, and let's not keep you waiting for 2 years, waiting for a Social Security disability decision, when you could be out there searching for something that you and your family can rely on.
Very good. Sean, I appreciate everything that you've done with us. Dennis, thank you for all of the insightful stuff, because a lot of our people don't get the distinctions between 607 and 207 and workers' comp and Social Security. There's a lot of minutia that goes on in there, and people confuse a lot of what goes on, especially the active and inmate and all that. That's it for this month's edition of COBA Monthly. I'm Brian Sullivan, and I'd like to thank Sean Reardon, Dennis Morris for being here today with us. We'll be back next month for the September edition. I had hoped to bring Kevin Curtin in here. I think he was a little bit late. He didn't get his the invite till this morning. I tried to stretch it out as long as possible, but Kevin can't be here. But I'm sure Sean has his number. Talk to you next month. Thanks. Bye-bye.